43. Repealed by the Statute Law Revision Act, 1893, 56-57 Victoria, c. 14, UK. The section read as follows. 89. Each of the Lieutenant Governors of Ontario, Quebec, and Nova Scotia shall cause writs to be issued for the first election of members of the Legislative Assembly thereof in such form, and by such person, as he thinks fit, and at such time, and addressed to such returning officer, as the Governor-General directs. And so that the first election of member of Assembly, for any electoral district, or any subdivision thereof shall be held at the same time, and at the same places, as the election for a member to serve in the House of Commons of Canada, for that electoral district. 44. A new Class 1 was added by the British North America, No. 2, Act, 1949, 13 George VI, c. 81, UK. That Act and Class 1 were repealed by the Constitution Act, 1982. The matters referred to in Class 1 are provided for in subsection 4(2) and Part 5 of the Constitution Act, 1982. As enacted, Class 1 read as follows. 1. The amendment from time to time of the Constitution of Canada, except as regards matters coming within the classes of subjects by this Act assigned exclusively to the legislatures of the provinces, or as regards rights or privileges by this or any other constitutional act granted or secured to the legislature, or the government of a province, or to any class of persons with respect to schools, or as regards the use of the English or the French language, or as regards the requirements that there shall be a session of the Parliament of Canada at least once each year, and that no House of Commons shall continue for more than 5 years from the day of the return of the writs for choosing the House, provided, however, that a House of Commons may in time of real or apprehended war, invasion or insurrection be continued by the Parliament of Canada, if such continuation is not opposed by the votes of more than 1/3 of the members of such House. 45. The original Class 1 was renumbered by the British North America, No. 2, Act, 1949, 13 George VI, c. 81, UK, as Class 1A. 46. Added by the Constitution Act, 1940, 3-4 George VI, c. 36, UK. 47. Legislative authority has been conferred on Parliament by other acts, as follows. 1. The Constitution Act, 1871, 34-35 Victoria, c. 28, UK. 2. The Parliament of Canada may from time to time establish new provinces, and any territories forming for the time being part of the Dominion of Canada, but not included in any province thereof, and may, at the time of such establishment, make provision for the constitution and administration of any such province, and for the passing of laws, for the peace, order, and good government of such province, and for its representation in the said Parliament. 3. The Parliament of Canada may from time to time, with the consent of the legislature of any province of the said Dominion, increase, diminish, or otherwise alter the limits of such province, upon such terms and conditions as may be agreed to by the said legislature, and may, with the like consent, make provision respecting the effect and operation of any such increase or diminution or alteration of territory in relation to any province affected thereby. 4. The Parliament of Canada may from time to time make provision for the administration, peace, order, and good government of any territory not for the time being included in any province. 5. The following acts passed by the said Parliament of Canada, and intituled respectively, an Act for the temporary government of Rupert's Land and the Northwestern Territory when united with Canada, and an Act to amend and continue the Act 32 and 33 Victoria, Chapter 3, and to establish and provide for the government of the province of Manitoba, shall be and be deemed to have been valid and effectual for all purposes whatsoever from the date at which they respectively receive the assent, in the Queen's name, of the Governor-General of the said Dominion of Canada. 6. Except as provided by the third section of this Act, it shall not be competent for the Parliament of Canada to alter the provisions of the last mentioned Act of the said Parliament, in so far as it relates to the province of Manitoba, or of any other Act hereafter establishing new provinces in the said Dominion. subject always to the right of the legislature of the province of Manitoba to alter from time to time the provisions of any law respecting the qualification of electors and members of the Legislative Assembly, and to make laws respecting elections in the said province. The Rupert's Land Act, 1868, 31-32 Victoria, c. 105, UK, repealed by the Statute Law Revision Act, 1893, 56-57 Victoria, c. 14, UK, had previously conferred similar authority in relation to Rupert's Land and the Northwestern Territory upon admission of those areas, to the Constitution Act, 1886, 49-50 Victoria, c. 35, UK, 1. The Parliament of Canada may from time to time make provision for the representation in the Senate and House of Commons of Canada, or in either of them, of any territories which for the time being form part of the Dominion of Canada, but are not included in any province thereof. 3. The Statute of Westminster, 1931, 22 George V, c. 4, UK, 3. It is hereby declared and enacted that the Parliament of a Dominion has full power to make laws having extraterritorial operation. 4. Under Section 44 of the Constitution Act, 1982, Parliament has exclusive authority to amend the Constitution of Canada in relation to the Executive Government of Canada, or the Senate and House of Commons. Sections 38, 41, 42, and 43 of that Act authorize the Senate and House of Commons to give their approval to certain other constitutional amendments by resolution. 48. Class 1 was repealed by the Constitution Act, 1982. As enacted, it read as follows. 1. The amendment from time to time, notwithstanding anything in this Act of the Constitution of the province, except as regards the office of Lieutenant Governor, Section 45 of the Constitution Act, 1982 now authorizes legislatures to make laws amending the Constitution of the province. Sections 38, 41, 42, and 43 of that Act authorize legislative assemblies to give their approval by resolution to certain other amendments to the Constitution of Canada. 49. Added by Section 50 of the Constitution Act, 1982. 50. Alternative provisions have been enacted for 4 provinces. An alternative was provided for Manitoba by Section 22 of the Manitoba Act, 1870, 33 Victoria, c. 3, confirmed by the Constitution Act, 1871, 34-35 Victoria, c. 28, UK, which section reads as follows. 22. In and for the province, the said legislature may exclusively make laws in relation to education, subject, and according to the following provisions. 1. Nothing in any such law shall prejudicially affect any right or privilege with respect to denominational schools which any class of persons have by law or practice in the province, at the Union. 2. An appeal shall lie to the Governor General in Council from any act or decision of the legislature of the province, or of any provincial authority, affecting any right or privilege of the Protestant or Roman Catholic minority of the Queen's subjects in relation to education. 3. In case any such provincial law, as from time to time seems to the Governor General in Council requisite for the due execution of the provisions of this section, is not made, or in case any decision of the Governor General in Council on any appeal under this section is not duly executed by the proper provincial authority in that behalf, then, and in every such case, and as far only as the circumstances of each case require, the Parliament of Canada may make remedial laws for the due execution of the provisions of this section, and of any decision of the Governor General in Council under this section. An alternative was provided for Alberta by Section 17 of the Alberta Act, 1905, 4-5 Edward VII, c. 3, which section reads as follows. 17. Section 93 of the Constitution Act, 1867, shall apply to the said province, with the substitution for paragraph 1 of the said Section 93 of the following paragraph. 1. Nothing in any such law shall prejudicially affect any right or privilege with respect to separate schools which any class of persons have at the date of the passing of this Act, under the terms of Chapters 29 and 30 of the ordinances of the Northwest Territories, passed in the year 1901, or with respect to religious instruction in any public or separate school, as provided for in the said ordinances. 2. In the appropriation by the legislature or distribution by the government of the province of any monies for the support of schools organized and carried on in accordance with the said Chapter 29, or any act passed in amendment thereof, or in substitution therefor, there shall be no discrimination against schools of any class described in the said Chapter 29. 3. Where the expression by law is employed in paragraph 3 of the said Section 93, it shall be held to mean the law as set out in the said Chapters 29 and 30, and where the expression at the Union is employed in the said paragraph 3, it shall be held to mean the date at which this act comes into force. An alternative was provided for Saskatchewan by Section 17 of the Saskatchewan Act, 1905, 4-5 Edward VII, C. 42, which section reads as follows.